Good morning and welcome to the November 15th, 2021 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley. I'll be the Land Use Hearing Officer today. And please stand if you're able and we'll salute the flag. All right, thank you. Again, I'm Pamela Jo Hatley. I'm the Land Use Hearing Officer today. Now I would like to introduce Mr. Tom Hisney of the Hillsborough County Development Services Department. He'll introduce staff and any agenda changes.
Good morning, Ms. Hatley. Yes, I'm Tom Hisney with the Hillsborough County Development Services Department. To my left is Rosa Timoteo. She also works for Development Services. Throughout the course of the meeting, we will be joined virtually by a number of planners on the Development Services staff. Also, we are going to be joined virtually by County Attorney staff, Mary Dorman. I have the following changes to the agenda. Agenda page 6, item H1, variance 21-0853. The applicant is Wesley Harrell. This application is a reconsideration and therefore will be heard as item E1 on page 4. Second change is agenda page 7, item H6, variance application 22-0016. The applicant is Diana Street Partners, LLC. This application is being continued by staff to the December 13th Land Use Hearing Officer meeting. I will now read the published continuances and withdrawals. Item A1, variance application 21-0902. The applicant is David Wright. This application is being continued by the applicant to the December 13th, 2021 Land Use Hearing Officer meeting. Item A2, variance application 21-1248. The applicant is Maria del Rosario Perez and Guillermo del Rio. This application is out of order to be heard and is being continued to the December 13th, 2021 Land Use Hearing Officer meeting. And finally, item A3, special use application 21-1374. The applicant is Shaughnessy Dobish. This application is out of order to be heard and is being continued to the December 13th, 2021 Land Use Hearing Officer meeting.
Thank you, Mr. Hisney. All right, so before we proceed, I'll read some meeting procedures. First of all, if you have any devices, noise-making devices, please silence those at this time. The agenda today consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and will submit a decision within 15 working days after the conclusion of today's public hearings. My decisions will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation today will be as follows. First of all, variances. Mr. Hisney will call the case. The County Department or Development Services Department will have 5 minutes to present its report and findings. Proponents will have 15 minutes to present arguments in support of the, I'm sorry, I skipped one. County Development Services will go first. The applicant and the applicant's witnesses will then have 15 minutes to present the proposal. Then proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. Then county staff will have 5 minutes to present any amended findings or comments. And then the applicant will have 5 minutes for rebuttal and summation. In special use cases, Mr. Hisney will call the case. Then the applicant and the applicant's witnesses will have 15 minutes to present the proposal. And then County Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present its findings of compliance or non-compliance with a comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will then have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. Please note the 15 minutes that are allotted to proponents and opponents is the total time allotted among them. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among you. You may wish, if there are a number of people who wish to speak on any item, you may wish to designate a single spokesperson. When you come to the microphone this morning, please first state your name and address for the record. This meeting is being recorded, so please speak into the microphone so that your testimony can be recorded. When you're finished speaking, please see the clerk to my right here to sign in for the record. Now we'll hear from Assistant County Attorney who will state the legal requirements for procedures for appeal of each item today.
Good morning. This is Mary Dorman from the County Attorney's Office. This Land Use Hearing Officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed the case, the record of that case is also closed and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the appeals board.
Thank you, Ms. Dorman. All right. Again, all testimony taken today will be under oath. So if you plan to speak today, please stand if you're able and raise your hand, and I will swear you in. And anyone online who plans to speak virtually, please also raise your hand to be sworn. All right. Do you swear or affirm the testimony you are about to give today is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Thank you. All right. Mr. Hisney, please call the first case.
We have no vested rights cases, fee waiver cases, or remands on today's agenda, which then takes us to Section E. Item E1 is variance application 21-0853. Staff findings will be presented by Chris Grangillard.
Chris, you're muted.
Good morning. I'm Chris Grangillard, planner with Development Services. I'm here to present application variance 21-0853. This application was heard on the August 23rd, 2021 Land Use Hearing Officer hearing. The hearing officer denied the variance on September 14th, 2021. The applicant then sought reconsideration of the matter as provided by LDC section 10.02.03.I, and the hearing officer granted the request for hearing on the application. The applicant is requesting a setback variance for an existing detached garage on a single-family lot zoned RSC 6 with an MH overlay. Variance per LDC section 6.11.04.c.2. Accessory structures that are 15 feet or less in height may occupy required side yards, provided they are no closer to the street than any part of the principal building on the same lot. And any lot abutting said required side yard and the structure is set back a minimum 3 feet from the side lot line, including agricultural features such as eaves and gutters. In the subject case, the garage is closer to the street, Ala Vista Drive, than a portion of the single-family home on the lot, and therefore must meet the required side yard setback. Per LDC section 6.01.01, a minimum side yard setback of 7.5 feet is required in the RSC 6 district. The applicant requests a 5.2 foot reduction to the required side yard setback to allow a setback of 2.3 feet from the west lot line. Findings, applicant states the garage is 12 feet in height. Per section 6.01.01, a minimum lot size of 7,000 square feet and minimum lot width of 70 feet is required in the RSC 6 district. Additionally, per LDC section 6.01.06, a minimum lot size of 1/2 acre of upland is required for use of a septic system. The subject property is served by a septic system and is 0.26 acres in size, approximately. Therefore, it is non-conforming. However, it has been certified as a legal non-conforming lot per NCL application 21-1023, which is in the case record. Also, the survey submitted by the applicant shows additional existing site nonconformities, which the applicant has elected not to address through the subject variance request. These include encroachments into a required 30-foot conservation area setback at the rear of the property, unless it is determined by natural resources staff that the setback is obliviated by a seawall constructed with approval of appropriate regulatory agencies, per LDC section 4.01.07.b. That concludes my staff report for variance 21-0853 reconsideration. We're glad to answer any questions.
Thank you very much. All right, now we'll hear from the applicant. Mr. Harrell? Are you representative? Thank you.
Madam Hearing Officer. My name is Raphael Rashkin. I'm an attorney for the owner, Wesley Harrell. And just thought we would start off. Is the Elmo working? It'll be helpful to have a view of the property here so we can see what we're talking about. It's a very awkward parcel, as you can see. So the Mr. Harrell's lot.
Excuse me, Madam Hearing Officer.
There we go. Perfect.
The applicant, I believe, represented himself at the first hearing and did
Yes.
not have representation. So we don't have an affidavit to authorize an agent. However, the property in the file, that the property owner is here that could confirm that he's authorized it.
Okay, thank you, Mr. Hisney. So, Mr. Harrell, we need you please to come forward, state your name and address in the record and in the microphone, and state on the record that you have represented your attorney here to, that you've authorized him to represent you today.
Okay, my name is Wesley Harrell, 9910 Ala Vista Drive, Gibsonton, and I do have representation here that I do authorize to deal with this matter.
All right, thank you.
Thank you very much.
Can you please come sign in, sir?
Mr. Harrell, come sign in with the clerk's office, please. Thank you, sir. Mr. Rashian, you can go ahead.
Yes, thank you. So Mr. Hurl's property is a triangular lot here. You can actually see it pretty clearly. This is the property line that comes down here. This is the garage that we're dealing with today. The property line comes down to the road. The road is not a through road, but it actually dead ends at this property and the neighboring property. The property is a triangle, as you can see, which was noted before in the previous hearing. But I think we need to have a little more focus on the difficulty presented by the shape of this property. At the previous hearing, the application was denied for the owner having a self-made hardship for the garage being moved up. So that we can see what we're talking about here. The garage used to be, you can actually see the gravel and rock here. It used to be up a little bit further here. Now, when it was in that spot, it was still violating the setback, even the standard 3-foot setback. And my understanding, this is legal non-conforming and had been there for decades. But there's a few problems here. One, it's in a floodway. But at the end of the day, it's also in violation of the 30-foot wetland setback, or it was its previous location. Now, it still violates the side yard for the current standards, I should say, setback, but it no longer violates the 30-foot wetland setback. It's actually in compliance with that now. There's space between it and the river, which was the whole point of moving it, was to get it away from the water. And to get it out of the way from any kind of flood waters that pour off the property. So that's why it was moved. When you look at the lot itself, there really isn't anywhere else to put a structure, an accessory structure at all, considering the current setback rules. It's a very awkward piece of property. And as we know, when these districts are being zoned, there's a presumption, and when these rules are coming out, there's a presumption that lots are going to have some sort of dimension to them. And there's an idea of what a lot is going to look like. When you have a triangular piece of property like this, you end up with very strange orientations that you have to do to try to comply with the rules the best you can. That's why you see the house here in a diagonal shape, a diagonal layout, instead of being, actually facing one way or the other. Because of this, there's really nowhere else to put this garage or any kind of structure. I would submit to Madam Hearing Officer, I would submit that this is a classic case where variances should be considered. And indeed, we met 5 of the 6 criteria at the last hearing. The one criteria, as I mentioned, that we're looking at is the condition created by the owner, but the condition shouldn't be, or the hardship is not that the garage was moved. The hardship is the shape of this property. It doesn't matter who owns this property. You can't do anything with this property or put anything anywhere because it's going to violate one of the setbacks, just the way the lot is formed. So, I think that's really the key here. It's not that it's all of a sudden violating a side yard setback. It was in violation of that before with the legal non-conforming. It's actually better now. It's actually not in violation of the 30-foot wetland setback in the back. And yes, you still have the issue with the side yard setback, but it's no worse than it was before. We would submit this is a good case for a variance. And the hardship, again, is the shape of the lot that we should be focused on.
Mr. Rashi, I have some questions for you.
Yes.
First of all, you mentioned floodway, and I believe this was something that the applicant mentioned.
Yes.
Please define for me what that is. And there was a document submitted, it was an elevation certificate.
Yeah.
And there was a reference to it that it was somehow related to that floodway issue. Can you connect those dots for me, please?
Yeah, I can. The best I can. When Mr. Hurrell was seeking to have this permitted and closed out, originally, and this whole issue came up, one of the concerns presented by the county was that where the garage was moving, it would affect how the water flows off the property. So if that happened, you could have flooding neighboring properties. You could change the grade of the land. All sorts of bad stuff can happen when you do that. So what's required by the code is to have one of these no-rise analysis done. So Mr. Harrell actually hired a engineer at great expense to go out and take all sorts of measurements. There's a 60-page report. But at the end of the day, it was determined that moving the garage from this location to here had no effect on how the water was going to flow off the property. Now,
Well, let me, if you don't mind,
yes.
the report that was submitted, I did read it, or at least the report that's in the record. I don't recall that even being part of that report. It appears to be simply stating what the elevations are on the property.
I read through the report. I'm not trying to argue with.
Okay.
Okay, this is my understanding. My understanding is what we were looking at is that the project that's being done is not going to affect one way or the other how the water is going to flow off the property. That's hence the no rise and floodway certification, that it's not affecting it. So that was my only point. The point.
In the findings I made, did I not make a finding that that there of the 6 hardship criteria, did my findings not reflect that there wouldn't be impacts to other property owners?
Oh no, you're here. That was decided very clearly.
Okay.
The only reason I mention it is just to explain kind of the background of why we end up.
So I think the issue today is whether or not it was a self-created hardship.
Okay.
And as I recall, the testimony was that Mr. Harrell was rebuilding an existing garage and found that it was in more of a dilapidated state than he thought. And so he needed to completely rebuild it. And while he was at it, he just decided to move it.
Yes.
And that is what created the need for a variance, because it put it in a position where part of the house, or where it's closer to the road than parts of the house. So it has to meet the primary structure setbacks. Isn't that the problem?
Okay. There's a lot there, but yet, yes and no. The only difference I would submit is that there does seem to be a focus on this, that the garage has gone closer to the road, and that makes it so that there's this setback issue now. But what I'm saying today is that actually hasn't changed. That was an issue before. This house was built on the same slab, so we know that garage was less than 3 feet from the side of the property, from the property line, which violates even the accessory structure setback requirements. Now, my understanding is that this was legal non-conforming, and the problem we're having is that we moved it, and I understand that. But what I'm submitting today is that it's no worse or more of a violation today than it was, 3 years ago. If anything, this property is now a little bit more in compliance in the spirit of the Land Development Code. I think that's the goal of these things, especially when you have legal non-conforming structures, is to eventually, not have them be non-conforming. And that's what this allows.
So are you saying then that the applicant cured one nonconformity?
I would say that, but I wouldn't focus. I just want to make it clear. My thesis statement here is not that we cured a conformity. I think that's worth mentioning and considering. But my thesis statement here is that what really the issue is, it doesn't matter where this garage is. The hardship is in the property shape. It's in the triangular shape of this property that makes it near impossible to develop it in any residential purpose. I mean, eventually, if the house got wiped away in a hurricane, I don't know how you rebuild on this property without some variances. It's a very difficult piece of property. I think that's the hardship here that we're dealing with.
I understand that. I understand the shape of the property. Yes, sir. I believe the issue, again, I bring you back to this, that the garage was, the applicant chose to move the garage, and that in itself created a situation where now it's subject to a different setback. And how is that not a self-created hardship?
Okay. What I can point out, again, and I don't mean to belabor the point, I just want to make sure my reasoning is clear, is that this idea that by moving it, now it's violating a setback. If we're talking about the side yard setback, it was in technical violation of that setback for current standards before it was moved. So it's not that we created there's no new hardship or new anything created by moving it down this line. It is just as far away from the property line as it was before, and we know that we know that that's less than 3 feet before. So it was less than 3 feet from the property line before, which is what's required. So this idea that, by moving it back, all of a sudden there's a side yard setback problem, that was a problem before. And it's, we can say that's a problem now, and that's why we're here for the variance. But there's no new condition created by it now, triggering the 7.5 foot setback. It's the same issue. It's still it's still too close to the side yard, which it was before.
I understand. Okay, I don't have any more questions for you. Okay.
That's all I have.
Then just stand by. You'll have an opportunity for rebuttal. And also please see the clerk and sign in. So now we'll hear from, if there's anyone here or online who wishes to speak as a proponent of this application.
Sir, I need you to come sign in with me, please.
Thank you. All right, I don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. County Development Services, anything further?
No. No, ma'am.
County Development Services, I just want to clarify that the issue here is that because now there's a portion of the accessory structure that is closer to the road than a portion of the house, that does require then the accessory structure to meet the primary structure's setbacks. Is that the case?
Yes, ma'am.
Okay. So the side yard setback that it is required to meet now is actually greater than it was where it was before. Is that correct? Or do we know that because it's been moved?
Yeah, Madam Hearing Master, without looking at a previous survey,
Okay.
I don't know that it would depend of whether the south face of the previous garage was closer to the street than any part of the house.
Okay.
If it had been, then that 7.5 foot setback would have been in place previously. I don't know if in the record we have anything showing the location of the previous garage.
All right. Thank you. And again, the non-conforming determination that we have in the record is for the size of the lot and the fact that it is on septic tank. It doesn't have anything to do with this accessory structure. Is that correct?
That is correct.
Yes.
Okay. Thank you. All right, Development Services, I don't have any further questions for you. Applicant, you have 5 minutes for rebuttal.
Madam Hearing Officer, I think I've said what I have to say.
All right, Mr. Harrell? Certainly. Yes, the applicant. We'll hear from the applicant. Thank you.
I guess I just want to make sure that I point out that from my perspective, yes, I started repairing a structure. On the side yard, we used part of the slab that was already there, so it has not changed the position off of that side. If I had not have moved it up some, that's all I did. When we talk about moving it, I slid it up a little bit. It would have been in a wetland setback, and it would have been in what my engineer called the floodway. Now, I don't really understand. She said to me, "You are like an inch I mean, it's almost like you knew exactly, if you see that little angled part on the garage, she said that would have been in the floodway. Now, again, I don't understand all that. She told me I was very fortunate that that angled part that we angled there you can see the angle on the side of the garage. And we just angled that to kind of mimic the house. But would have been in the floodway. So she said to me, so the good news is you're not in a wetland setback and you're not in the floodway. All the calculations are good. You're all set. Yes, the property was a little close to the line before. It's no closer now. It's in a better position in relation to the floodway, in relation to the wetland setback. It's just simply that little, because the back part of the house is lanai. So you're talking about a few feet. 95% of the house is closer to the road than 95% of the garage. I feel like what I did, and yes, I started repairing it, and man, I wish I'd have left some of it up, for sure. But I wanted a nice structure. I have on record that the neighbor came and was thrilled because it is in a better position. It's no closer to their property than before. So I guess, I feel it's reasonable to say, well, point being, a couple other things. If there's no way, if I would have had it back where it was, she just said, it's in the floodway and this structure, moving it front helped those calculations. And I feel like overall, it's a better situation than it was before. So that's all I would like to say.
Thank you, Mr. Harrell.
Thank you.
Okay. All right. So this will close the hearing then on this reconsideration, case number 21-0853.
That concludes section E of the agenda. We'll now move to section F, site development variance request. First case is item F1, variance 21-1054. The applicant is NRS LLC. The request is for a variance to the wetland conservation area setback. Staff findings will be presented by Carla Shelton.
Good morning. This is Carla Shelton with Hillsborough County Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on July 8th, 2021, is to allow for construction of a retaining wall within the 30-foot wetland conservation area setback. The summary, per LDC section 4.01.07B4, no filling, excavating, or placement of a permanent structure or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a retaining wall across the width of the lot within the 30-foot wetland conservation area setback. The applicant requests a 25-foot reduction of the setback to allow for a setback of 5 feet. Findings. Number 1, per the comment sheet from the Environmental Protection Commission, the wetland line depicted on sheet 1 of the site plan appears slightly different than the wetland line approved by EPC on February 15th, 2021. The proposed retaining wall must be located landward of the EPC approved wetland line per the wall detail cross-section on sheet 2 of the site plan. Finding number 2, a wetland setback conservation planting plan has been provided on the plan dated August 9th, 2021 that provides a compensation planting area equivalent to the amount of encroachment. This concludes the staff report from Development Services.
Thank you, Ms. Shelton. May I ask about that finding number 1? Do we know what the slightly different issue is? What's slightly different?
That was the comment that was made by the Environmental Protection Commission reviewer who reviewed this wetland variance request. I am not sure what the slight difference is, but both plans are in the file. The plan that they approved on February 15th, 2021, and the plan that was submitted by the applicant on July 8th, 2021. And the EPC reviewer does go on to say that sheet 2 of the site plan does show the cross section and shows the wall 5 feet away from the wetland line. They just want to make sure that the wall does not encroach any closer to the wetland line than 5 feet.
All right, thank you very much. Okay, applicant, please. Is the applicant here?
Howdy, Chuck Juneau, Tampa Seawall.
All right, thank you. And your address, please.
4707 West Bayview Avenue, Tampa, Florida.
All right. Go ahead.
I don't have anything for you. Just need here to answer any questions you may have.
Oh, I see. All right. Well, the application is for a waiver, and the waiver has to be, of course, supported by evidence of a hardship. Do you have any testimony regarding the hardship criteria on this parcel?
I don't. It should be written in the application.
Okay. I'll review that. Can you explain the question I asked Ms. Shelton related to the difference in the wetland setback line in that the EPC approved and that appears in the plan?
It was probably just done off the survey that we took. That when the EPC comes out and does their wetland delineation mark, they set flags. Sometimes those flags gets moved. They're just little flags. And there's other construction activity going on, so some of them could have got obstructed or something, but we're still within the 5 foot land of the setback of the wetland delineation mark.
So is it are you with the company that's going to be constructing
Correct.
the seawall?
Yes.
Yes. And is it your testimony that your company will construct the seawall 5 feet landward of the wetland line?
Yes, we will.
Okay. Based on the
wetland delineation mark that was flagged by the EPC.
By EPC.
Correct.
Okay, thank you. Anything further?
That's it.
Okay. I need you to sign in with the clerk's office, please. All right. Is there anyone here or online who wishes to speak as a proponent of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Don't hear anyone. All right. County Development Services, any further?
Nothing further from the county.
All right, thank you. And applicant, you have an opportunity for 5 minutes more. Did you have anything further, or is that it?
No.
Nothing. Okay, thank you. All right, this closes the hearing then on variance 21-1054.
Our next case is item F2, variance application 21-1223. The applicant is William Alvaro Diaz. They're requesting a variance to encroach into a wetland setback. Staff findings will be presented by Carla Shelton.
Carla Shelton with Development Services. This request is a request for a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on August 18th, 2021, is to allow for construction of a portion of a swimming pool and deck within the 30-foot wetland conservation area setback. Per section 4.01.07B4, No filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a portion of a swimming pool and deck within the 30-foot wetland conservation area setback. The applicant requests a 13.75-foot reduction of the setback to allow for a setback of 16.25 feet. Findings: the variance request 21-0201 for this property heard at the February 22nd, 2021 Land Use Hearing Officer hearing was denied. That request was for a 17.17-foot reduction of the setback. This request has reduced the distance of encroachment by 3.42 feet. The previous variance request was for 1,398 square feet of encroachment into the 30-foot wetland setback area. This request has reduced the amount of encroachment by 794 square feet to a total of 604 square feet. Finding number 2, a wetland setback compensation planting plan has been provided on the supplemental information plan dated August 18th, 2021 that provides an equivalent square footage of compensation planting to the amount of encroachment. That concludes this report.
Thank you, Ms. Shelton. All right, we'll hear from the applicant.
Madam Hearing Officer Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg, Florida. I do have a PowerPoint for you. I'm here this morning with Mr. William Evero Diaz. This site and Mr. Evero Diaz, you've met before. This is an application we're bringing back to the hearing officer for your review. So this is variance 21-1223. Next slide, please. We're located in the northern part of Hillsborough County. Next slide, please. Just off of Tarpon Springs Road in Odessa. Next slide, please. So as I indicated, this is reapplication of a recently denied setback variance. Madam Hearing Officer, this is based upon a completely different set of criteria, and the variance requested has been reduced. Next slide, please. Single-family home. Carla did a good job reviewing this. We appreciate her help getting here today. Seeking a variance in a 30-foot wetland conservation area. It's a 13.75-foot reduction of the required setback to allow for 16.25 proposed setback. My number there is wrong. Carla had it right. It's 604 square feet of encroachment in terms of total square footage. Next slide, please. So again, it was denied. Today is reduced. This is a comparable from the past to today, which has been a reduced request, obviously both for square footage and setback. Next slide, please. And as Carla indicated, we're providing an equivalent amount of square footage of compensation planting for the amount of encroachment. Next slide, please. And as I've said twice, but importantly, this stands on its own, is not presented under the same criteria previously. Next slide, please. And next slide, please. This is the property as the property appraiser has it. Next slide, please. And this is the site plan noting the setback distance as proposed. Next slide, please. And here is the critical aerial. Hearing officer, and I'm sure your eye goes to the same place, which is on the subject site, you see that there is a dramatic and immediate impact or difference of the lot compared to the others, as you can see on this aerial. When Mr. Evero Diaz came forward to me asking me to look at the variance, I looked at the site to see what I felt would meet variance criteria, and this stood out very strongly as a definable, unique, singular hardship. As you can see very simply, the backyard area of the property is considerably different and non-existing as compared to the others. Next slide, please. Next slide, please. A little closer view. Again, you can see that as you get closer that it is a pretty significant area of difference there in terms of that backlot area. Next slide, please. By Google estimate, and this is strictly an estimate by Google online, I show it as 46 feet. That's of course going to differ per the moving shoreline, but I try to line it up as best I could with the ground or with the lot ending elevated area to the north. Next slide, please. And again, just another view. Next slide, please. And this is on the ground, as you can see what the condition is of that area. Next slide, please. And this is on the survey showing that edge of water undulation as it changes and moves in regard to the property. Next slide, please. This appeared to be a naturally occurring dynamic. I'm just a zoning guy, but I looked at the aerials from 2002, 2019. Appears there have been some type of environmental scouring or changing of the land, although of course it's vacant. So it certainly is not caused by the applicant or by prior owners of the property. Next slide, please. In regard to FAR, I have their FAR on the property less than 50% of what's allowed in terms of the structure and the size of the lot. Next slide, please. So looking at the criteria 1, the alleged hardship practical difficulty is unique and singular. I think the aerial speaks for itself. There is a significant impacting and hardcore practical difficulty that's not suffered in common with other properties similarly located. Criteria number 2 is the little requirements of the DC would deprive the property owner of rights commonly enjoyed. That's certainly the case in our opinion, as we've shown you that there is a hardship or practical difficulty, which is very impacting on the site, that would deprive the property owner of the same rights in terms of development in the rear of the lot as others in the immediate area would. Criteria number 3, would the variance have allowed substantially interfere with the range of the rights of others? We don't believe it would be. The variance has been noticed twice. There's been no one who's come forward to objection that I'm aware of or have heard of. And this would appear to me, in our opinion, to be affecting only this single lot. Number 4, is the variance in harmony with and does the variance serve the general intent, purpose of the LDC? We believe it does, because when a variance is recognized based on criteria, it does fall within the harmony and general intent of the code. What Mr. Alvarez is seeking is a pool which is, of course, extremely prominent throughout Hillsborough County, be able to do it in a minimum fashion. Criteria number 5. Next slide, please. Situation self-relieved by the variance result from legal act or action by the applicant. That's certainly not the case. And will allowing the criteria 6, will allowing the variance result in substantial justice being done concerning both the public benefits intended. We believe it is. There is a plan that is presented into the file that the planting or green material will meet code requirements, and it will provide, in our opinion, substantial justice in that the individual hardship is being addressed and can be addressed by the variance in a unique, practical way. So with that, we ask your attention or your consideration, and we hope to have that. I do have a copy to put in the record.
Thank you, Mr. Pressman. I have a couple of questions for you.
Sure.
First of all, regarding different criteria, of course, all variances are based on the 6 hardship criteria. And we know that this case is based on the same hardship criteria. But I believe what you're presenting is that there's a different set of facts because the plans have changed. Is that correct?
Well, I think you stated it better than I. Thank you. Yes.
Okay.
That's, so the criteria that I addressed first time around are not involved with the criteria that
I understand. It's a separate case. It stands on its own. I do understand that.
Thank you.
And I'll review the new plans. Has the size of the pool or the shape of the pool or the area changed somehow? What has been done? Reconfigured it?
We have reduced the setback. William, do you want to respond to that specifically?
Okay, Mr. Alvaro Diaz, please state your name and your address for the record first.
My name is William Alvaro Diaz. Address is 18107 Joreen Road, Odessa, Florida.
Thank you.
Yes, the pool itself had a extended decking around it, which added to the encroachment as well as the side basically running along the back of the house. I've taken all that out and just basically left the pool itself. That's all I've done.
Okay, thank you. And also,
Does that answer your question?
yes.
Okay.
Well, I guess one more. Are the new plans in the record?
Yes, that was part of the PowerPoint.
Okay. The criteria on self-created hardship. All right, let's address that. The applicant, of course, acquired this property and knew it was on a lake, and I understand it's the size of the parcel is what it is, but the upland area is what he has to build on. And the upland area, you pointed out, Mr. Pressman, is smaller than neighboring lots because the lake contours a bit and makes that upland area smaller. Is that correct?
That's correct.
Okay. So when the applicant acquired this property, that was an obvious characteristic of the property. And yet the applicant designed a home and built a home that is the size that it is, so that when the pool is added, there's an encroachment in the wetland conservation setback area. So please help me understand how that is not a self-created hardship. How is it that the need for this variance was not created by the applicant's design of his home and later addition of a pool, which creates the need for the setback?
I think that's a good point. However, with all due respect, you could apply that to virtually any variance coming before you. You could say in any variance, well, you're asking for a setback. You knew that coming in. Why did you build so big? The fact of the matter is that this is a singular, unique condition on this property. So according to the criteria, if you find it to be, with all due respect, if you do find it to be a unique hardship, which we believe strongly it does, and that it wasn't created by the applicant, and the other criteria, then this lot is special, this lot is different, and a variance should be awarded. It's not, in effect, it's not really a cause and effect. In other words, the lot's small than everybody else because of a natural reason, so build a smaller home. I would submit to you with respect, it's the opposite, that here's a lot that we want to build, or Mr. Alvarez built to under FAR standards, and he's not able to do everything he wants to do because this lot is different. This lot is smaller. He's impacted. That's the precise reason for a variance. So if you were to say, with every setback coming before you, change what you want to build, don't make it so big, that doesn't support a variance. I understand why that's a concern of yours, but the question then becomes, what is the issue with the variance? So it's an element of recognizing the criteria of a bona fide shortness or difficulty on this property, which we do. I would tell you to look at it in that way rather than the other side saying, how much did you build? And you have a smaller lot. Recognition or being aware of a condition on a property does not forfeit you, in my opinion, to have a variance. It's a question of saying, I think we do have a variance on this property. I think we do meet this criteria, and we should be afforded an area to make up for it as the criteria allows.
All right, one more quick thing, because you keep, Mr. Pressman, you've mentioned floor area ratio several times. Is there such a standard for this lot, or does it have to do more with the impervious ratio that, or the coverage that is allowed on this lot, and being a residential zoning?
Well, I chose to look at FAR because that's typically what I look at to see if something's overbuilt or not. And in this particular case, the FAR is extremely low, less than half of what FAR allows.
And is it FAR based on a commercial use? Is that where are you getting the FAR for this lot?
Under the R1, as I researched it, under the R1, the maximum FAR is 0.25.
Okay, thank you. I don't think I have any more questions for you right now.
We appreciate your consideration. Thank you very much.
Thank you.
We would stress and ask you to look at the criteria on each item, and we are absolutely convinced, looking at this lot, it meets every criteria. Thank you.
Thank you, sir. All right, are there any persons here or online who wish to speak as proponents of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
Nothing further from staff.
All right, thank you. And then applicant, you actually are allowed 5 minutes for rebuttal or summation if you wish to take it.
Well, I never turned down a microphone, but I think we're done and we appreciate your attention. Thank you.
All right, thank you, Mr. Pressman. That closes the hearing then on variance 21-1223.
Okay, our next case is item, excuse me. Yeah, I'm sorry. Our next case is item F3, variance application 21-1230. The applicant is Vivian and Eddie Suarez. They're requesting a variance to encroach into a wetland setback. Staff findings will be presented by Carla Shelton.
Per land development, the applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on November 3rd, 2021, is to allow for placement of a retaining wall and a portion of a residential structure within the 30-foot wetland conservation area setback. Per LDC section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a portion of a residential structure and a retaining wall with fill material within the 30-foot wetland conservation area setback. The applicant requests a 30-foot reduction of the setback to allow for a setback of 0 feet. Findings. Per the comment sheet from the Environmental Protection Commission, the retaining wall installation is not authorized to be placed in the wetland. Finding number 2, a wetland setback compensation planting plan has been provided on the site plan dated November 3rd, 2021 that provides an equivalent square footage of compensation planting to the amount of encroachment. That concludes this report.
Thank you. All right, applicant, please.
How you doing?
Good morning. We need your name and address for the record, please. Thank
Eddie
you.
Suarez. Do you want the address of the property? Is that what you're looking for?
Your address.
My address is 5892 Hendricks Lane, Mapleton, Georgia, 30126.
Okay.
And I'm here on behalf of my father.
All right. Go ahead, Mr. Suarez.
Okay. Excuse my ignorance. You know, we're here doing this for ourselves. So, yeah, so basically, this property was purchased and we did have the knowledge of the wetland area and the 30-foot wetland setback. We made the property as small as possible and we moved it over as much as possible to be within the side setback of the 7.5 feet to the neighboring home. And it's going to be a 2-bedroom property. Most of the properties in the area are at least 2 to 3 bedrooms. And my parents are building this house for themselves so that they can retire and live in this property. And just to be able to live there comfortably and not be pigeonholed down to a 1-bedroom, we had to encroach on this setback. That way they can have that 2nd bedroom.
What is the square foot of the house?
The total site is 1,056 square feet, and the actual inside square footage is 864 square feet.
It's not really related, but how is the access? What is the access to this property?
There's a street that is not paved. I believe I don't know if it's Coolidge, but it's actually not paved. They paved some of it, but they didn't finish it, and that's where the access is. Yeah.
Okay, thank you. All right, so I mean, the lot is sizable, but there's just a small area of
Very tiny.
buildable area.
Exactly.
I see.
And I believe there was a letter submitted by one of the neighbors that are in favor. And we've met the neighbors. They're really nice people, and they would love to have us. My parents have lived in the area for over 25 years and worked in the area for over 25 years, and they're just ready to settle down, retire, and enjoy life in this house.
Okay, and the house as it's designed and where it's placed on the lot meets the setbacks to the side yards and the front yards, is that correct?
Yes.
Okay. Did you hear the comment from the Environmental Protection Commission that the retaining wall is not authorized to be within the wetland? You're asking for a 0-foot setback.
Yeah.
So who's building the retaining wall for you?
Inside Out Construction. We're talking with them. They're the ones who presented that wall, I guess, so the house can be built up a little bit and have somewhat of a yard. And that's why they included that wall.
Oh, I see.
Yeah.
All right, but the wall will not be built in the wetland.
No.
Okay. All right, do you have anything else that you want to add? That you wish to add? No.
Yeah, we're just trying to build a home. You know, my parents sold their previous home. They're renting a room right now. You know, we're going through the process. We're ignorant to the process. It's been costing a lot of money to try to do this. And, you know, they just want to build a home for themselves. We're not trying to resell it. This is where they're going to retire, and they just want to live out the rest of their lives at this property.
All right, thank you.
Thank you.
I need you both to sign in with the clerk's office, please.
Just want to say thank you for the consideration.
Yes, sir. Since you've spoken, would you please state your name and your address for the record?
My name is Eddie Suarez, and I live at 14816 Park Club Circle.
Thank you, sir. And sign in with the clerk's office. Okay. All right. Is there anyone here or online who wishes to speak as a proponent in favor of this application? All right. Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Don't hear anyone. All right. Development Services, anything further?
Nothing further from staff.
Okay. And applicant, you're entitled to 5 minutes for rebuttal and summation. Did you want to add anything further? That's a no. Okay. Thank you. So this closes the hearing then on variance 21-1230.
Takes us to section G of the agenda, sign variances. We have one application. It's item G1, variance 21-1345. The applicant is Creative Sign Designs. They are requesting a sign variance. Staff findings were prepared by Kim King. However, due to unforeseen circumstances, she cannot attend today's meeting, so I will present the finding. This request is for a sign for a proposed car wash on Big Bend Road. They're requesting two variances. One is for the setback required for the proposed monument sign. The other is for the size of the sign. The Land Development Code allows 1 square foot of sign area for every foot of street frontage. This parcel has 50 feet of street frontage, which would allow 25 feet of sign area per side for a total of 50 square feet of sign area. Their request is to increase that amount by 126 square feet total, which would allow 88 square feet of sign area per side for a total of 176 square feet. As far as the setback, the code requires that a 4-foot high monument sign have a 15-foot setback from the right-of-way line. And that setback is increased by 1 foot for every foot of height above 4 feet. In this case, the proposed sign is 15 feet high and is required to have a setback of 26 feet. They are requesting a setback reduction of 11 feet to allow a setback of 15 feet. I'm available for any question.
Thank you. All right, applicant?
Addie Mentry, 12801 Commodity Place, Tampa, Florida.
Thank you. You can bring the microphone down, yes.
Thank you. Okay, I have a PowerPoint presentation. Thank you, Tom, for your presentation. All right.
Excuse me now, is this presentation already in optics?
It is not. I have a PowerPoint to
Thumb
submit
drive
to
that
the
you leave
record.
behind for the clerk?
Yes, sir.
Oh, great, thank you.
Yes. Okay, so this sign variance is for Bubble Down Car Wash. It does not currently have an address on the property appraiser, but the address that was requested with the building permits is 10763 Big Bend Road. Next slide. The general location is the southwest corner of the county, located off of Big Bend Road, about 2 miles from 75 and 0.6 miles from 301. Next slide. Here is a location of the parcel. This is located within a larger master development for Summerfield Crossings. This specific development has 7 businesses, 4 tenants in the front and 2 tenants in the back, separated by an access drive. This parcel, although Tom and Kim's presentation said it had 50 feet of road frontage, I have on our record that it has around 149 feet as presented in the design package that was submitted.
Okay, I did have a question about that.
Yes.
And looking at the survey and looking at the plat, actually.
Yes, ma'am.
It appears it is a 50-foot frontage, actually.
Okay.
And the little piece that runs further over from the actual frontage of the property is part of that. It appears, at least from the plat and the survey, it appears to be part of that. I believe it's parcel A. Are you familiar with that? Parcel A in the
That
plan?
runs along the folio and the access drive. Is that folio?
It runs
or
along.
parcel A?
If you see where the parcel there is outlined in red,
Yes, ma'am.
okay, then it appears that right on Big Bend Road, there's a frontage,
Yes.
and that's the 50-foot frontage. That's my understanding. And then from that point, it notches in just a little bit.
Mhm.
And then it goes over, and if this is a north-south, I guess it would go over to the east, and then it notches
Yes.
down a bit and further over, then back down. It's just sort of like a stair step.
Okay.
So it appears to me, at least, and I wondered if you have different evidence, present it, please. But it appears to me that the 50-foot frontage is correct, and that little notched out parcel is owned by all of the owners of that entire development there. Shared as a sign
Mhm.
parcel.
Yes.
Is that your understanding?
Yes, so that is correct based on what we have. My understanding of the code was not that it needed our property frontage needed to be directly abutting, but I would say that it is correct that the direct abut of the folio is probably 50 feet.
Okay, thank you for
Yes.
clarifying that. I think the issue is that there's an actual parcel
Mhm.
between,
Yeah.
even though it's very narrow.
Yes.
Okay, I understand. Thank you.
Okay. Next slide. No further questions.
No, go ahead and
Okay.
with your presentation.
Okay,
Yes, thank you.
So we are asking for one monument sign. I know that when Tom presented, he said the variances we were asking for was 2. Under our understanding, we needed to also the monument would also count as an additional sign, and I will get into information later in the presentation on that. But we are requesting one sign location. The square footage that we have calculated is 88.21 square feet per side. The overall height is 15 feet and the setback we are requesting is 15 feet from the parcel. Therefore, we would be asking for an additional sign location, 38.12 square feet per side of square footage and a setback decrease of 11 feet. And then you can see on the slide, this is the proposal of what the sign will look like.
All right.
Next slide. So the variance details. So we were under the understanding that we needed to ask for an additional number of signs because as you can see on the folio, there is a green box and an orange box. A variance was granted to this development, I believe in 2018, for advertisement, for an additional sign for advertisement of the back 3 folios. Because the back 3 tenants, 5, 6, and 7, do not have traditional street frontage along Big Bend Road, they cannot have a traditional ground sign as per code. Therefore, they requested a ground sign to be to advertise for those tenants abutting Big Bend Road. Unfortunately, the variance was approved, but it was not only to advertise for tenants 5, 6, and 7, because I believe then it was on tenant 2, which is Bubble Down's folio. I think since it has been, they have been parceled out, this parcel and tenant 2, Bubble Down's folio. The approved sign has a tenant panel for tenant 2 because it was originally on that land. So that is why we were under the understanding, because this has tenant 2 and we're asking for the Bubble Down sign, that it needed to be an additional number of sign. However, Bubble Down will not use that tenant panel. We are requesting our own sign.
Okay, well, that's complicated, isn't it?
Yes.
So the green box there, then in this slide, is the sign that
The
is
existing.
that serves all of the tenants.
So it doesn't serve all of the tenants. It serves the back tenants, 5, 6, and 7,
Right.
and tenant 2.
So there's a small place on that sign for tenant 2, but
Yes.
you're not going to use it.
Correct.
And that sign is on that parcel that's actually not your parcel.
Yes.
Okay.
Yes.
I understand.
Next slide.
Do you happen to have that variance number?
I don't.
Okay, no
I
problem.
don't.
That's fine. Thank you.
So this is the sign that was presented and approved. So this is, it was for, the variance was not, the variance, because it held tenant 2, was a variance to allow for 5, 6, and 7, but the variance was also for an additional square feet of sign. So traditionally, what would be allowed is 50 square feet per side, or an aggregate total of 100. This sign is proposed at 10 by 10, so it is 100 square feet per side, 200 square feet total. And as you can see, tenant 2 is at the bottom and has 15 square feet or 30 square feet total on this sign, and 5, 6, and 7, because they are bigger box stores, has more, although it was on tenant 2's site.
Okay. And this sign is there.
This sign is existing. I have a photo of it
Okay.
on the next slide.
And how tall is this sign?
This sign is 20 feet in overall height.
Okay.
Which I believe, actually, now that I'm looking at it, is also variance, because along this corridor, signs are only allowed to be 15 feet in overall height, per my due diligence with Kim King.
Thank you.
Next slide. So this is the sign as it currently stands. This photo was taken about 2 weeks ago. So as you can tell, there is a blank panel on the sign. If our variance is considered and approved, we would go back to the developer and just ask, or have them go back to Fairfield to take that entire panel up. That way, all 3 tenants have equal amount of signage, and there's not a blank panel there. Next slide, please. So we wanted to point out that although this sign isn't a unique, we have a unique situation with this sign, that the other 3 folios that abut Big Bend in this development have their own sign. So the Culvers, Panda Express, and a multi-tenant site, they all have their own signs. So they are allowed, they're allowed their full roadway visibility, while tenant 2 is not.
Well,
So in
just to back up, tenant 2 is allowed a sign, correct?
tenant 2, I believe based on Kim's
Okay.
presentation, now I believe it was, but that was not my understanding upon due diligence and working with Kim.
Okay. So in other words, because you thought that this existing sign was on Lot 2's parcel or somehow affected Lot 2's parcel.
Yes, and I mean, I do question that because if this existing sign has a panel for tenant 2 and we are allowed to have a sign, which do we choose?
Okay.
We would obviously like our own sign as kind of symbiotic with the folios that front Big Bend.
Okay. Do you know the sizes, the height, for example?
So the Culver's sign is 12 feet in overall height.
Okay.
The Panda Express sign is 8 feet 8 inches. And I believe the multi-tenant sign is also around 8 feet.
The one on.
Yes, the
Okay,
far.
Okay.
Yes.
And you think it's about 8 feet?
Yes, ma'am.
Okay. Thank you.
And we also wanted to point out just the separation. So the separation between the Culver sign and the Bubble Down sign is about 200 feet. The separation between the sign, the Bubble Down sign that we're proposing, and the existing multi-tenant sign will be about 129 feet. The separation between the multi-tenant sign and the existing Panda Express sign is only about 20 feet. And then the Panda Express and the multi-tenant is about 200 feet as well. So we believe that we are giving adequate separation between the signs to not overcrowd Big Bend. Next slide. So that was our variance on the additional, though I'm not sure if that was needed or not. So our variance detail on the setback. So we are requesting a 15-foot setback for this, which is a decrease in 11 feet for the setback that is needed due to the existing pole sign and due to the configuration of the parcel. The only place to put this sign is the northwest corner of the parcel. Due to that and due to the setback that is needed for travelers that are going east, I believe, on Big Bend, the monument sign would hinder the visibility of the wall signage, especially with the square footage that they're allowed. I believe for the wall signage, we're only allowed 46 square feet. And normally with the branding standards, Bubble Down likes a 200 square foot sign. So we know that obviously we need to maintain the square footage that we're allowed per code, and that's about 46 square feet. So with the hindrance of the monument visibility based on the building setback and the setback that is needed through traditional code, we have kind of compensated and brought up the monument sign so that it can be a main focal point of the site instead of travelers not being able to see the full monument, especially with the with an entrance not being off of Big Bend for the site. None of the folios on that have exact entrances from Big Bend. They have to either go before, enter before or after on Summerfield. I don't know the south entrance. So we wanted to ensure, the safety of travelers. They would be able to see the sign. And if you go to the next slide, I have a view. This is about 100 feet back on the turn lane to go into the first turn. So the red square you'll see, because they have not been under construction yet, I needed to just kind of drop in where the location that this will look like, but it will be visible about 3 feet above the Culver's sign. It is proposed to be basically in line with the signs, to be symbiotic with the development, but you will be able to see the sign, and so for public safety, travelers will be able to know to turn.
Do you know how far the Culver sign is from, where is it in relation to the setback or to the right of way? And I guess what I want to understand is the proposed sign, you're requesting a setback variance. Where will your sign fall in the sort of line of sight things? And I see the red box, that's your sign. So is it set back further from the Culver sign? Will it be set back further from the Panda Express sign?
So from what I was able to gather from optics, the Culver sign did not get a setback variance. Therefore, because it is a 12-foot sign, it then requires a 22-foot setback.
Okay, I'm asking a lot of questions.
Oh.
I'm gonna give you 2 minutes.
Oh, okay.
Okay.
So that's our setback requirement. We feel that the setback should be decreased for public safety, for visibility, and to compensate for the lack of square footage based on the entrance that we need from the private drive. And the relationship and configuration of the parcel.
Okay.
Next slide. And then the last variance that we are requesting are square footage. So our square footage proposed is 88.21 square feet for each side with a total of 176.42. As I understand now, we directly, the 50 feet directly abut. So therefore we'd only be allowed the 25 square feet per side. Though we believe that this sign, number one, with the visibility that we just saw, would be is designed to make sure that it is viewable for traffic safety, to ensure that travelers are turning into the development and know that this is here, especially going down with Culver's based on the building setback, and where this is part of Culver's will obstruct the square footage on the building, and therefore we've compensated with the ground sign. We also, wanted to stick within, respect the code, but we wanted to stick within the Bubble Down brand standards. It's very important for, this is an emerging enterprise. I believe that you saw a variance for a site on Falkenberg a few months ago, and Bubble Down has bought and is opening several more sites in the area, and so we really feel like we want to ensure that they have local recognition, and it is important for the branding to, state that it is the car wash, that it has free vacuums, and the EMC.
Okay. Did you have anything further? Is this does that conclude?
I had one more slide.
Okay. We'll have,
It's just, it was just an average daily count. So based on Plan Hillsborough, that's just the average daily of 30,000 people.
Okay.
Yep.
I do have one more question for you. The size of the sign, and you're asking for quite a bit of an increase in the variance. So is this the standard Bubble Down sign size?
So actually we had a meeting. So the standard is that they want a 30-foot pole sign at 200 square feet. I wanted to ensure that when we brought this to you, that number one, the corridor is only allowed to have 15-foot signs. I wanted to maintain the corridor. We also wanted to make sure that other than, the existing sign and a couple signs that are on the other side of 301, most of the signs in the corridor are monument signs. So I wanted to ensure that we kept a kind of a symbiotic relationship with the signs that are already around. But no, this is not necessarily the brand standard. And although we're requesting a variance for some unique circumstances, I wanted to ensure it was tasteful and kind of within what the corridor had.
Okay. All right. Thank you very much. And please sign in with the clerk's office. All right. Is there anyone here or online who wishes to speak as a proponent of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Don't hear anyone. We'll go back to County Development Services then.
With regards to the number of signs permitted on the parcel, if the Bubble Down parcel were a single parcel and the entire frontage of it meaning tract A was still part of the Bubble Down parcel, right? Then it would be one parcel. It's less than 300 feet of frontage and indeed would be limited to one sign. However, as you pointed out, and early on it was shown on the graphics, tract A was this kind of gerrymandered tract that was created specifically to put a sign for the entire shopping center. And that actually occupies the frontage. So the Bubble Down site is its own parcel. So it's allowed one sign. So I think maybe the idea that another variance was required here kind of maybe goes back to when tract A was part of the Bubble Down site, but that's not the case. However, if there's any question in the applicant's mind that a third variance is required here, then I would recommend you ask for a continuance to the next hearing to have that examined. To my read of the code and my discussions with Kim, the two variances that are in the report are the only two variances that are needed. However, Kim is not here to discuss that in more detail. So I'm leaving it to the applicant. If you believe a third variance is necessary here, then I would recommend you continue this to the next hearing to before this case is closed. It's your call.
I mean, based on everything that you said, I understand, and I don't think that a third variance is needed. I think traditionally through code, because this is their own folio, they are allowed to have their own sign. I just want to make sure that if there needs to be a condition that we don't use the tenant panel on the existing, because that is named there. I'm not sure if that needs to be written in there, but we don't have, we are not going to use the tenant panel on the existing sign.
Okay, and Mr. Hisney, I think I just want to ask it a different way, and I also want to clarify something. The applicant testimony was clear that that shared sign on parcel A is not for the entire shopping center, but it's for lots 5, 6, 7, and also lot 2, that there's a space for lot 2. And so my question then was, does the sign count against a property owner if there's signage allotted to them, but it's on a different parcel? And I think it's the same thing you addressed. But I think maybe we should ask the applicant if they would put on the record that they are going to forgo any right to advertise on that lot, I think, or on parcel A sign. I think they've already testified that they are going to.
And if you would, in your judgment, if you would want to make that a condition of approval of this variance, that,
Yeah.
you or the applicant can offer it, is that?
Yes, we testified to forego any advertising on the existing sign on tract A for approval of the sign that is on our folio. We would traditionally be allowed. It was just through initial due diligence with Kim, because that was on there, we needed the kind of additional number.
Okay. All right. Is that all from Development Services?
Yes, ma'am.
All right, thank you. All right, so applicant, then just to, you have 5 minutes for rebuttal and summation. So just to clarify, you do not wish to ask for a continuance about that other issue?
No, ma'am.
Okay, so the third variance, you're just requesting a variance in for the setback and for the sign size, correct?
Correct.
And you're willing to accept a condition of approval that you will forgo advertising on the tract A sign?
Correct.
Okay. Did you have anything else you wanted to add?
I don't, unless there's any other questions. We appreciate your consideration.
All right, I don't have any questions for you.
Thank
you. All right, that closes the hearing then on variance 21-1345.
Well, that takes us to section H of the agenda, which are general variances. First case H1, variance 21-0853 was heard at the beginning of today's meeting because it was a reconsideration, which then takes us to item H2, variance application 21-1154. The applicant is Renee Rodriguez. The request is a variance to lot development standards. Staff findings will be presented by Tanya Chapella.
All right, Ms. Chapella?
Yes, can you hear me?
Yes.
So the applicant is requesting a variance to the required rear yard setback for a proposed covered patio on a single-family lot, zone PD. So permitted projections into required yards, covered patios, requirements, regulations, would require that covered patios may intrude no more than 13 feet into the required rear yard. However, in no case shall the permitted intrusion of the covered patio reduce the yard that is provided to less than 10 feet. For the current conditions of approval for PD 98-1539, the required rear yard setback on the subject property is 10 feet. The applicant requests a 7-foot reduction to the required rear setback to allow a setback of 3 feet. That concludes my presentation.
All right, thank you, Ms. Chapella. We'll hear from the applicant.
Good morning, Rene Rodriguez, 8562 Acorn Ridge Court, Tampa. It was hard to hear what Mr. Chapella was saying, that the quality of the audio wasn't all that great. But basically, yes, we're trying to get a variance to allow us to put a covered patio behind our home. There is an existing slab there. We're trying to enjoy the benefits that many of our neighbors today enjoy, in that a covered patio keeps the weather out, keeps your furniture dry. And in fact, I do have a photo, if I may.
Please, thank you.
So this is our home here in the dark, and these are our neighbors who have also previously gone through the same process to get a variance to allow them to have a covered patio over there, behind the home.
Mr. Rodriguez, and I'm looking at a similar photo from the property appraiser's website. There's something, a structure or something in the back of the house already. Is that what is that?
So that's a great question. That used to be a screen covering.
Oh, okay.
So when we moved in, the community was in the process of being painted, and the screen structure was in poor condition. So we decided to have it removed. So when they did the painting, all the track marks and things like that would not show up on the wall of the home. So that was removed, and we want to use the same square footage that was there before, but only this time include a covered patio, as you see, as the neighbors have done.
So right now, what's there is just a surface, right? It's tiled or it's concrete?
It's been tiled over, but it is a concrete slab that's been tiled over.
Okay. And so all you're going to do is screen it in?
With a covered roof.
Okay.
Yes.
So you're going to, the existing tile, concrete tile covered surface, you're just going to screen that in?
Correct.
Okay. All right. Is there anything else you want to add?
Unless you have questions then.
No, those were really my questions.
Thank you.
All right. Thank you. Be sure and sign in with the clerk's office here. Thank you. All right. Is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Don't hear anyone. Development Services, do you have anything further?
No, ma'am, nothing further.
All right, thank you. And applicant, you're actually entitled to 5 minutes for rebuttal and summation. Did you have anything further you wanted to add? No, thank you. Okay. That will conclude then the hearing on application 21-1154.
Our next case is item H3, variance application 21-1303. The applicant is Daryl Hahn. They are requesting a variance to accessory structure requirements. Staff findings will be presented by Sam Ball.
Good morning, Sam Ball, Development Services. The applicant is requesting a height variance for an existing, excuse me, I'm sorry, I'm the wrong. The applicant is requesting variances to accommodate a proposed detached garage on property zone ASC1. According to section 611-4B, accessory structures more than 15 feet in height shall meet principal building setbacks. LDC section 60101 requires a 15-foot side setback and a 50-foot rear yard setback. The applicant requests a 12-foot reduction to the required side yard setback to allow a setback of 3 feet from the west property line and a 40-foot reduction to the required rear yard setback to allow a setback of 10 feet from the south property line. LDC section 61104B limits accessory structures to a height not to exceed 15 feet except where the accessory structure meets the primary setback of the district. Because the proposed garage will not meet the principal building setbacks, the applicant requests a 3.5 foot increase to the maximum height for the proposed garage to allow a height of 18.5 feet. That concludes my report. I'm available for questions. Thank you.
All right, thank you, Mr. Ball. All right, applicant?
Good morning. My name is Frank Shiano. I'm the homeowner. I live at 13208 Oak Street in Odessa, Florida. We're asking for a variance due to where the house was built. The maximum garage space we could have is 4,000 square feet, but because the house was built so far back before I purchased it, I can't have the setbacks because it would obviously encroach on the house. It would be in the house. So we're asking for a 10-foot and a 3-foot variance so that we can put the building in the far back corner of the property to keep it out of visual, just make it look neater and for the neighborhood.
Okay. And when was the structure built?
The house?
No, it's a proposed garage.
Yeah, no, we haven't done anything yet. No, we want to get permits before we build it. We don't
Thank
want
you.
to cause any problems.
That's a very good idea.
We're trying to do it the right way.
Okay. I'm sorry, I'm trying to pull up the aerial now so I can take a quick look. Okay. All right, I see. So you'll be 3 feet from the side
Yes, ma'am.
and 10 feet from the rear property line.
Yes, ma'am.
Okay. And so going to the hardship criteria, any variance, of course, is based on hardship criteria. So can you explain what is unique about this lot or the configuration or something about this lot? Just talk about that a little bit, please, why this is, why the variance is required.
The variance is required because whoever built the house built it so far back on the property line, there's not enough room in the back to put the garage behind the house to keep it out of, basically, so it's not an eyesore. We don't want a big building in front of the house. In the neighborhood, it would look kind of weird, so we're trying to put it in the back of the house so it'd be out of sight, kind of, to keep the neighborhood looking nice and calm. And because of whoever built the house, they built the house so far back, there's nothing else we could do.
Mm-hmm.
And we can't build it on the other side because that's where there's a septic tank and there's the well. So it was kind of seemed to be the perfect place to put it out of the way.
All right.
I spoke to my neighbors. None of them that I'm aware of have any issues. Everyone seemed okay with it. So.
Okay, understand. And just looking at your survey, it's difficult really to see from this where exactly the residence is, but will all of the structure be in back of all of your residents?
I think it overlaps next to the residence by a couple of feet, maybe 2-3 feet.
Okay. All right, so some portion of the proposed garage will be will overlap basically with the rear end, the rear of the house.
Yes.
Okay.
Yes.
All right. I guess I have a question for development services then. Does that trigger any further side yard setback, Mr. Hisney?
Well, in this case, because the proposed accessory structure is greater than 15 feet high, the required side yard setback.
Is there already?
Right.
That's
So
right.
it's the same as if it had been less than 15 feet but was near the street, it would trigger the exact same side yard setback
Okay.
requirement.
Got it. That's correct. So the same side yard setback. All right. So part of the reason for your required variance then is the height of the structure. Why does the structure have to be so high?
I collect antique cars. I have a dozen antique cars, and I have like a 31 Chevy and a 41 cars that I don't use a lot. So I want to put lifts so I can put them up top and then put the cars that I drive normally down below. Just basically storage just for family heirlooms. That's what it comes down to.
I see. All right. All right. Anything additional information you want to add?
No, ma'am.
Okay. All right. Thank you. I need you to sign with the clerk's office, please. All right. Is there anyone here who wishes to speak as a proponent in favor of this application? All right. Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Do not hear anyone. All right. County Development Services.
Nothing further.
Okay. All right, applicant, you're entitled to 5 minutes more for rebuttal and summation. Did you have anything further you wanted to add? No. Okay. Thank you. That then closes the hearing on variance 21-1303.
All right, next case is item H4, variance application 21-1305. The applicant is K-Back Corp. They are requesting a variance to fence requirement. Staff findings will be presented by Tanya Chapella.
Tanya Chapella, Development Services. The applicant is requesting a height variance for an existing fence on a property zone ASC1. Per the Land Development Code, Section 60702, fences in agricultural districts must comply with the requirements for fences in residential districts. Also, fences over 4 feet in height shall not be allowed within required front yards. The required front yard in the ASC1 district is 50 feet. The applicant requests a 2-foot height increase to allow a height of 6 feet for an existing wood fence in the required front yard on the east side of the property. This concludes my presentation. Thank you.
Thank you. All right, applicant. Good morning.
Diana Turner. Do you want the property address or my actual residential address?
Your address, please.
11125 Roberts Lane, Riverview, Florida, 33578.
Thank you. All right, go ahead.
Just need a variance because the fence in the front is taller than it's supposed to be, I was told. We live right across from the elementary school. The property's been in the family for years, and it's always been an issue. People like to stop and park out front. They like to look through the fence. They like to take pictures. We have issues with school. It's crazy, I'm telling you. I get 4 phone calls a day of people sending me pictures of my own property that I own, wanting to buy it or wanting questions. So the school also, just because everything, the kids drop paperwork, we've picked up trash for years. It blows through the fence. It blows over the fence. The fence is a very nice fence. It is an existing fence. I did call and ask if I could put it there. I guess I forgot to ask how tall it's supposed to be. So,
okay. So you had a fence there already.
There was a chain link fence there that was there for years and years, and it was dilapidated. People would park on that side of the road and hit the fence, and it was literally falling down.
And what did you replace it with?
Wood fence, privacy fence.
I'm sorry,
wooden,
a privacy fence.
Custom built, not like you buy at Home Depot. I had somebody come in and build it board on board. Nice fence.
Okay. And it is 6 feet tall.
Yes, ma'am.
All right. And it looks like a pretty good sized property. The house is fairly far off the street, right?
Yes, ma'am.
And someone lives there now. Is it
My daughter actually lives there with my 3 granddaughters.
I see.
And the house sits so far back, the kids play out in the front yard. But when the other fence was there, people would stop, literally. And on the weekends, people park at the school and they pull into the school and face the house with their lights on. And numerous times we've had to call the sheriff.
Was the chain link fence a 4-foot high fence?
It used to be. By the time we tore it down, literally it had been hit and dilapidated so much,
I
yes.
understand. Okay. Could you have put a 4-foot wood fence there?
I could have put a 4-foot, but if somebody pulls up to a 4-foot fence, they're just going to look right over it. Normal person is 5 foot, 5'7". So, and literally my daughter has called me and said, Mom, there's people out front taking pictures. The kids can't even go outside. And one of the children's bedrooms faces the road and it has a window as big as huge windows in it. So people are looking in.
Okay, I understand. All right, anything additional? All right, please sign in with the clerk's office. Thank you. All right, is there anyone here or online who wishes to speak as a proponent in favor of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
Nothing further.
Okay, thank you. All right, applicant, you're entitled to 5 minutes for rebuttal and summation. Did you have anything else you wanted to say? No. Okay, thank you. That closes then the hearing on application variance 21-1305.
Our next case is item H5, variance application 21-1312. The applicant is Laralde Investments Incorporated. They're requesting a variance to allow a flag lot in the urban service area on residentially zoned property. Staff findings will be presented by Steve Beachy.
Good morning, Steve Beachy, Development Services. The applicant is requesting a variance to create a flag lot in the urban service area for a proposed 2-lot subdivision of a property zoned RSC 6. Per Land Development Code Section 60201B4A, a single parcel to serve a single dwelling unit, a flag lot, may be created through a certified parcel subdivision, provided the subdivision is located within the rural service area and in an agricultural zoning district. The applicant requests a variance to allow a creation of a flag lot in the urban service area on a property that is residentially zoned. Our findings are that the subject property is in the urban service area and will be required to connect to a public water and sewer, and the applicant will be required to meet all applicable county access and driveway spacing regulations. That concludes my comments.
All right, thank you. Applicant, please.
Ariel Laralde, 15114 Pennington Road.
Hi.
So, a little nervous. I'm always nervous. So this is the proposal. Just trying to make a 20-foot. I'm required to do an ingress, egress. So this is. It's 20 foot, the requirement.
All right, turn that microphone on, please, and you can, there you
Okay.
go.
This is the 20-foot requirement. This is Pennington Road. This one's already public sewer and water, so I would just have to deal with the one in the back. I just want to be able to use the lot to split it in half, and that's it.
Okay.
I had required originally an easement. They said no. Then I had used a few examples that are here, that down the street on Pennington also, but Pennington actually curves into a street. It becomes a actual street. They're building currently, it's actually almost done, a brand new construction. So that's what I use as comparison. But they're saying, no, go ahead, we will need a flag lot, which I understand. It makes a lot of sense. Because when you have easements, then you start having arguments. When it's a flag lot, obviously the person in the back will own the one in the front. They'll own the easement. Then you have another 10-foot on the side, which would be for the people in the front. So there wouldn't be any
Understand. All right, and all right, I guess I really don't have any questions for you. Your goal is to split the property into two, and the proposed homes will otherwise meet setbacks and so forth.
Yeah.
They'll be on public water and sewer, and you're just creating a 20-foot wide access driveway essentially for the home in the back. And the home in the front will have its own access to the right of way.
Correct.
Okay. All right. Anything further you want to add?
No.
All right. Please sign in with the clerk's office here. Is there anyone here or online who wishes to speak as a proponent in support of this application? I don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I don't hear anyone. Development Services, anything further?
Nothing further.
Okay. Applicant, you're entitled to 5 minutes for rebuttal and summation. Did you have anything else you wanted to say? No? Okay, thank you. All right, that will close the hearing then on variance 21-1312.
The next case is item H6, variance 22-0016. This case, however, was continued to December 13th, Lujo, at the beginning of this meeting. That then takes us to item H7, variance application 22-0031. The applicant is Sonora Tampa Bay, LLC. They're requesting a variance to lot development standards and fence requirements. Staff findings will be presented by Sam Ball.
Okay. Good morning, Sam Ball, Development Services. The applicant is requesting a height variance for an existing fence and a setback variance for an existing dwelling on a property zoned ASC4. According to LDC Section 60702C2, fences in agricultural zoning districts are regulated in the same manner as fences in residential districts, except under certain circumstances which do not apply in this case. Per LDC Section 60702C1A, fences over 4 feet in height shall not be allowed within a required front yard that functions as a front yard. The applicant requests a 2-foot increase to the maximum permitted height to allow a 6-foot high fence within the required 50-foot front yard on the north side of the subject property along Clement Road. According to LDC Section 60101, the required minimum front yard setback in the ASC1 district is 50 feet. The applicant requests a 0.6-foot reduction to the required front yard setback to allow a setback of 49.4 feet from the north property line. That concludes my report. Thank you.
Thank you, Mr. Ball. All right, applicant.
Morning, Dale Corum, 4601 Country Hills Drive, Tampa, Florida. I have a couple of layouts here. I'll put that one up first. So this is the property. I think the initial variances on the house itself, it's listed as a legal non-conforming of the 49.4, I believe, inches. The house was built in the 1946. I purchased the house. This was never brought up on any of the findings. So not quite sure what's going on with that. Just want to make sure that we, bring it up and make sure it's that part is legal and taken care of as far as it goes.
Okay, so Was this fence existing?
Excuse me, Madam Master. So in this case, that what the applicant is identified as Sonora Tampa Bay, and there's no designated representative, correct? All right. So are you with Sonora Tampa
Yes.
Bay, sir?
Yes, sir. Yes, sir.
All right. Can you testify to that on the record?
Yes, sir. My name's Dale Corum. I'm with Sonora Tampa Bay.
Okay. Thank you.
All right, tell me more about the variance you're requesting, existing fence. Part of it's in a wetland. You're going to remove that part, but you're, let's see.
So we have a couple situations with the property itself. I have my engineer record here with us. We're the black part that you see there is a steel storage building that we are trying to get erected, and we are putting up a koi and orchid farm. And we've had a lot of issues on this property since we purchased it. Theft is one of the main things. Also, on the back in this area here, there's a horse farm, and people just come wandering onto the property with their dogs, and they just go back to pet the horses, which is all good and fine, but the liability factor for us. So we put this fence up because of trying to, get this operation going, but also the fact that we're going to be raising koi fish, and koi fish can be very expensive, and the process of raising them, and we're just trying to make it where people are not disturbing the sensitivity of the raising of the fish. The other part is with the property itself, we have on the back side of the property is power lines. And with the 50-foot easement of the power lines, the 30-foot of the wetlands, and then 50 foot from the back, this is the proposed location for the storage building. There's no way to really protect it if I have to bring the fence back there, and then we lose all of this area here for grow farm and grow houses as well. So this document Ron put together here, this plan here shows the different setbacks that we are kind of having to deal with, and actual use of the property becomes very, very limited.
Okay, so it seems though that the issue is the 4-foot fence as opposed to a 6-foot fence.
Yes.
Okay, so I mean, the setback is not much, but the height of the fence. Talk about why you need a 6-foot fence instead of a 4-foot fence. You could have put a 4-foot fence, isn't that correct?
Yes, ma'am.
Okay.
So the situation with the 4-foot fence does not give enough privacy with having, let's just say at the front of the property, we have a fry pond is what they call them when you're raising the fish. People can see over the fence. They could easily access the property. A 4-foot fence is not that difficult to overcome. I mean, not that a 6-foot fence is either if somebody really wants to get in there, but it's the actual being able to see what's going on and seeing the fish there. People know what's there. The value of those fish can get immense if theft, and we've had theft on this property several times. They actually stole a $24,000 side-by-side. The sheriff had it on TV, and still to this date, and never been found. So just trying to protect, what we have.
Okay, I understand. Is there anything else you wanted to add?
I think that's pretty much it.
Okay. Please, and
My name-
state your name and address, please.
My name is Ronald Leader. I'm the engineer of record for a current site permit we're trying to obtain. My address is 4316 Fox Glen Lane, Tampa, Florida. And to to clarify, we appreciate Mr. Bell for assisting us to get this point as the planner. There were two matters. One was an existing condition. The house is 75 years old. That setback is off 7 inches, which Mr. Korn inherited when they approached. It was not disclosed during the. So we just want to put that on record now to put the fire out permanently. That matter, and then of course you just discussed the fence, which I have nothing to add in that regard.
Okay. All right. Is that all you have?
Yes, ma'am. I appreciate the consideration and,
All right.
hopefully with, we're just trying to, the safety and security of the property and what we're getting ready to do. Thank you.
All right. Thank you.
Thank you.
Please, both of you sign in with the clerk. Is there anyone here or online who wishes to speak as a proponent in favor of this application? Don't see anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right. Don't see anyone. Okay. Development Services, did you have anything further?
No, ma'am, nothing further.
All right. Thank you. And applicant, you're entitled to 5 minutes for rebuttal and summation. Did you have anything else you wanted to add? All right. That's a no. Thank you. So we're closing the hearing then on variance 22-0031.
Okay, our final variance today is item H8, variance application 21-1317. The applicant is Taylor Made Structures LLC. The request is a variance to accessory structure requirements. Staff findings will be presented by Sam Ball.
Good afternoon, Sam Ball, Development Services. The applicant is requesting a setback variance to accommodate an existing detached garage on a legal non-conforming lot that is zoned AS 0.4, but is subject to RSC2 district building coverage and setback requirements. According to LDC section 61104C, accessory structures shall be permitted in front yards at twice the depth of required front yards or 50 feet, whichever is left. Such structures shall not occupy required side yards. LDC section 60101 requires a minimum side yard setback of 10 feet in the RSC2 district. The applicant requests a 4.6 foot reduction to the required side yard setback to allow a setback of 5.4 feet from the west property line. That concludes my report. Thank you.
Thank you. All right, applicant.
Good morning, Jennifer Bliss, 3910 East Knights Griffin Road, Plant City, 33565. Good morning. Mr. Gibbs purchased this property back in April of this year. A couple months later, as a homecoming gift, he received a code compliance case against him. Apparently, the garage that was in the front of that yard was never permitted. So he's going to have to go through an after the fact permit, which he called our company to see if we could help with. So in the process of doing the diligence of finding out what his setbacks were, I've had to go through a non-conforming lot review and then also to come to find out that it was built a little bit into his side setback. So he is not doing any other improvements on the home or the property. He does, it would create a huge financial hardship for him to move this property. He's an ICU nurse, so I'm kind of speaking on his behalf. He just does not have the time to come and deal with this himself. But we're hoping that you would allow this property to just stay where it's at.
Okay, thank you. I know you're aware that all variances have to meet specific hardship criteria. And I understand the financial burden, but that's not part of the hardship criteria. The hardship criteria are more related to the property itself. So can you speak to the hardship criteria? What might there be about this property itself that requires the setback variance? How is it not a self-created hardship, that sort of thing?
Well, in my professional opinion, I don't feel like it's a self-made hardship because he did go through getting title insurance and felt like he did everything he was supposed to do before he purchased this piece of property to ensure everything was, the way it was supposed to be. So then to get slapped with this, he does not have a lot of room on his property. Matter of fact, on the other side of his property where that garage is at, there's a whole side of an easement. So for him to be able to move it, there's also a long driveway. So for him to be able to move, I don't believe he'd have the space.
Okay, where is the easement, please? And does it show, is there a survey on file that shows where the easement is?
Yes, ma'am. I did send it in with the application. Let me pull that survey up. I apologize. Hold on 1 second.
If it's in the record, I'll make sure and look at it.
It is.
And I see on the survey that's coming up, just what I have here, it appears to be an easement across the front of the property, a 35-foot ingress-egress easement or something?
Yes, ma'am.
Is that the one you're talking about?
Yes, that is correct.
Okay. And so I see the concrete drive and where the garage is. And I mean, I understand the current owner didn't build it. A prior owner apparently did, but it looks like it could have probably been moved over and certainly could have been permitted.
Right. And we are going through, or I'm going to go through the after the fact and get it up to, to compliance. But I would hope that the county wouldn't, require this homeowner to move it based on, he needs 4 feet on the side. I know that's, it's not supposed to be a financial hardship, but that's a huge financial hardship to have to move your driveway and to have to move your structure when you're basically just missing 4 feet.
Yeah. I understand. Thank you. Is there anything else you wanted to add?
No, ma'am.
Okay. Please sign in with the clerk here. Okay. All right. Is there anyone here or online who wishes to speak as a proponent in support of this application? Don't see anyone. Is there anyone here or online who wishes to speak in opposition to this application? Don't see anyone. All right. Development Services, anything further?
No, ma'am, nothing further.
Thank you. All right, applicant, you have 5 minutes for a rebuttal and summation. Did you have anything further? No. Okay, thank you. All right, that closes the hearing then on variance 21-1317. Do we want to take a break, Mr. Right. Yeah. All right, we're going to hear the next one and then take a break before the appeal. Okay. All right, we're going to hear the next case and then take a break before the appeal.
All right, so that takes us to section J of our agenda, which are special uses. We have one special use today, item J1, special use application 21-0606. The applicant is Dune, Florida Land One Sub LLC and South Shore Bay Club LLC. And the request is for a 4 COPX alcoholic beverage permit, which requires waivers and is also proposed on residentially zoned property. Staff report and recommendation will be presented by Steve Beachy following the applicant's presentation.
All right, applicant.
Good morning, Ms. Hatley, and good morning, Mr. Hisney. My name is John Grandoff. My address is Suite 3700 Bank of America Plaza, and I have the pleasure of representing the applicant this morning on application SU 21-0606AB. This is for the lagoon that has been built as part of this South Shore project, and we're requesting permission to sell alcoholic beverages. In the report that will be summarized by Mr. Beachy, the three waivers involve distance from residential, which needs to be 250 feet. We are 190 feet, so it's a 60-foot waiver. We have the following justifications. The waiver will not have a significant impact on the surrounding residences because the very purpose of the lagoon is to serve South Shore Bay community. This lagoon will comprise approximately 12 acres to serve the community as a community recreational use. Number two, the majority of the wet zoning uses will take place on the eastern side of the lagoon, which provides separation from the closest residential uses, which are located on the west side of the lagoon. And number three, the lagoon has one entrance, which is located on the east side of the property at Lagoon Shore Boulevard. The one entrance complied with the large size of the lagoon causes the actual distance to travel from the lagoon entrance to residential property much larger than the straight line distance identified in the survey. That's our justification. We have two other findings. The properties closest to the proposed use are located behind the gate in the Melody at South Shore Bay neighborhood, and the gating provides additional layers of protection. Finally, we're proposing the following hours of operation, 10 a.m. to 11 p.m. daily. The staff made three findings. I will leave those to Mr. Beachy to explain to you his findings because I think he's more qualified to do so. The staff finishes a recommendation from Mr. Hisney that the application is approvable, subject to three conditions, which are enunciated on page 3 of Mr. Hisney's report. Number one, the 4COPX alcoholic beverage shall be restricted to private park serving the South Shore Bay community, which includes South Shore Bay CDD and the Hidden Creek CDD only. It's very important. Number two, the sale and or consumption of alcoholic beverages shall be limited to residents of the community and their guests only. And number three, the sale or consumption of alcoholic beverages shall be limited to the following hours, as I enunciated earlier, Monday through Saturday, 10 o'clock a.m. to 11 p.m. and Sunday, 11 a.m. to 11 p.m. We concur with the staff findings, with the recommendation, and agree to the recommended conditions found in Mr. Hisney's report. Respectfully request your approval, and I'll reserve any further time for rebuttal. I also have a copy of the community plan as well as the survey to show to you if you'd like further clarification. Thank you.
Okay, thank you. Be sure and sign in with the clerk's office, Mr. Randolph. Thank you. All right, Development Services.
Steve Beachy, Development Services. The applicant seeks approval for a 4COPX alcoholic beverage permit for the sale and consumption of beer, wine, and liquor on the permitted premises only for a private community lagoon park that is under construction under PD 05-0210. The PD is part of the South Shore Bay development, which according to the applicant is comprised of the South Shore Bay CDD and the Hidden Creek CDD. Pursuant to Land Development Code Section 61111, alcoholic beverage permits that are requested for residentially zoned property require special use approval, regardless of whether the request permits applicable separation requirements. Additionally, in this case, the applicant is requesting a distance separation waiver from adjacent residentially zoned parcels. Per the revised survey received August 13, 2021, the applicant proposes a wet zone, a total of 12.7 acres, 555,219 square feet, which includes the 12.877 square feet, 12,877 square feet of indoor area. Per the revised, per the Land Development Code 611, a distance from the proposed structure to the residentially zoned property shall be 250 feet. As Mr. Randolph stated, the applicant requests a 60-foot waiver to the required separation requirement for the residentially zoned property. Staff findings are that the proposed wet zone will serve a private lagoon park. A relatively small number of existing homes are within the required 250-foot separation, and the closest homes are separated from the proposed lagoon park by Lagoon Shore Boulevard. Again, the proposed hours of operation are 10 a.m. to 11 p.m., which are generally more restrictive than the permitted by the Land Development Code, which are 7 a.m. to 3 a.m. For the reasons discussed, staff finds proposed wet zoning does not pose significant impacts on the surrounding land uses, and the necessity for the specific distance separation requirement is negated by the circumstances identified above. Therefore, staff finds the request to be approvable, subject to the recommended conditions. Approval is based on a wet zone survey received August 13, 2021. The recommended conditions are in the staff report, so I will not read them as Mr. Randolph has already read them, and that concludes my comments.
All right, thank you.
Madam Hearing Master, I'd just like to add one thing just to make sure. The requested hours were 10 a.m. to 11 p.m. daily. However, by ordinance, outside of the LDC, alcohol sales and consumptions cannot start until 11 a.m. and a.m. on Sundays. So that's why you'll see in the conditions why on Sunday the hours are 11 a.m. to 11 p.m. It's not a typo or anything.
Okay, good, thank you. All right, moving on then. Is there anyone here or online who wishes to speak as a proponent in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak as an opponent in opposition to this application? All right, don't see anyone. Development Services, did you have anything further?
Nothing further.
And applicant, you're entitled to 5 minutes for rebuttal and summation. Did you have anything further?
Thank you, Ms. Hatley. We agree with Mr. Hisney's clarification on the hours and also with Mr. Beachy's findings. I just realized that the overhead was here. Would you like me to show you the site plan or survey, or you have that in your backup?
I think I have it, and
Okay.
I have reviewed it and will again.
Okay. Thank you very much. Have nothing further.
All right, thank you very much. All right, so this closes the hearing then on application special use 21-0606. We're going to take a short break. We've got one case left, and we'll hear that in 5 or 6 minutes when we get back. Okay.
Thanks.
We are live in 3, 2, 1.
All right, welcome back. We're reconvening the November 15th, 2021 Land Use Hearing Officer meeting. Mr. Hisney, would you call the next case, please?
Our final case on the agenda today is in section I, which covers the appeals. It is I-1. Case number is 21-1295. The applicant is Lennar Homes. The applicant is appealing the administrator's decision regarding the preliminary plat application for the South Shore Point Townhome Project, that the application cannot be approved under the provisions of the Hillsborough County Land Development Code due to a finding by the Hillsborough County School District that the application is unable to meet the required level of service for schools. The administrator will be represented by Adam Gormley, the Director of Development Services in this matter.
Thank you, Mr. Hisney. All right, first, one thing I didn't mention at the beginning of the meeting is that my decision on this case, this appeal, will be submitted within 5 working days. That's required by the code. The code does not seem to set out an order of presentation on appeals. So I don't know if the county attorney's office has any guidance on this, but it would be, if not, it would, I believe we would hear from the applicant first as the appellant, and then from the county, and then the applicant will have time for rebuttal.
Madam Hearing Officer, this is Cameron Clark. You're correct. Section 100501, which governs this hearing, does not speak to order of presentation or time limits, which means those are up to the discretion of the hearing officer. Traditionally, the appellant would proceed first, though, since they are the reason that we're here. And certain hearing officers, often you can ask how much time that they would like. You can obviously limit testimony so that it's relevant and succinct. But the 100501 doesn't speak to these level of specifics.
All right, thank you, Mr. Clark. All right, we'll hear from the applicant first then, and will 20 minutes be sufficient for your presentation?
Thank you, Madam Hearing Master. I hope to be done much more quickly than 20 minutes.
Okay. Then we'll allot up to 20 minutes each side and 5 minutes for rebuttal if that works. And also, after you state your name and address for the record, I believe we have to rule on additional evidence that was submitted into the record as well.
Thank you, Madam Hearing Master. Rebecca Kurt, Brooks Shepherd and Rocha. I was going to say Assistant County Attorney, and that's been a long time. At 400 North Campus Street, I am representing Lennar for this project. And in addition, I have Michael Brooks from our firm. We did submit a lot of additional information, but it was mostly things that were either already in the record or things that we are allowed to under code freely reference, such as resolutions of the county. We just wanted to have a complete record all in one place so it'd be convenient for everyone. The additional information that we did submit was 2 emails, one from Assistant County Attorney Nancy Takamori and one from Mr. Gormley, and then a chart of other jurisdictions that we created. So the new information is actually very small. We submitted that timely a week ago, and I have not heard any objections back from the county.
Okay. So the Land Development Code provides that the hearing officer shall freely allow the presentation of additional evidence pursuant to this subsection wherever such is relevant to the issue on appeal. And I did see the items you submitted, and so I'll rule at this time that those items are allowed to be submitted to the record and will be considered.
Thank you, Madam Hearing Officer. We also have a binder that I'd like to submit as part of the record. It just is hard copies of some of them that may be convenient for you. If I could just submit that.
Is there anything additional that you didn't submit into the record
No,
yet?
there is nothing additional, and it's actually not everything because some of it I didn't think you actually would want hard copies of, but we did for your convenience print out some.
Okay, so I'll accept that, and then I'll leave it with the clerk's office to put into the record.
Again, Rebecca Kurt, I am representing Lennar on this project for South Shore Point Townhomes, which is a 190-unit townhome project located within the South Shore Corporate Park DRI. The project is currently has a application for a preliminary plat. Back in January, the project received a comment from the school board that there was no school capacity and no available capacity projects for which my client could pay and mitigate and move forward with its project. At that time, my client reached out to our firm to try to determine whether or not school concurrency was a vested issue under the South Shore Corporate Park DRI. All DRIs are different. They all have to be evaluated individually. In March of this year, we submitted a letter to the county attorney's office submitting our position that in fact, the South Shore Corporate Park DRI adopted in 2002 was vested from the school concurrency mandate that was contained in Senate Bill 360 and adopted in 2005. Subsequent to that request, we had contact with the county and they requested additional information about whether or not our project was utilizing entitlements from phase 1 of the project. There are 2 phases in this DRI. We submitted that information. Subsequent to that, there was another request for additional documentation that our project was utilizing entitlements in phase 1. We submitted that additional information. At that point, we continued to have conversations with the county requesting a response, but we did not receive anything until August when Mr. Gormley sent a letter reaffirming the original position that concurrency, school concurrency applies to this particular preliminary plat application and that there were no projects available for which us to pay mitigation. We believe in this appeal that that is error because under state law and the county code, the county is preempted from applying school concurrency to a DRI that was in existence at the time that school concurrency was mandated by the state. I'm going to take a brief step back into what is a DRI. I know that you know what a DRI is, but so I'm going to be very pointed. A DRI is a development that has regional impacts that is evaluated for the local and regional impacts at time of entitlement. After those entitlements are granted, they're vested from future comp plan and land development code amendments that affect those entitlements. This is an express preemption. It's contained in both 380.115 and also in 163, the Growth Management Act. It expressly says that nothing in this act shall limit or modify the rights of any person to complete any development that has been authorized as a development of regional impact pursuant to Chapter 380. It goes on to things that are not relevant. It's a very, very clear and express preemption. Moreover, when school concurrency was mandated by the state back in 2005 as part of Senate Bill 360, the final section of that act says, unless the developer elects otherwise in writing, the provisions of this act amending chapters 163 and 380 Florida statutes shall not apply to any development of regional impact for which a development order has been issued prior to the effective date of this act, which was July 1st, or for which a development of regional impact application has been submitted prior to May 1st, 2005. If you follow the county's code, you actually get to the same place. There are a couple sections in the Land Development Code that talk about vesting. There are sections in Chapter 4, which is your concurrency section, and then a vesting section in Chapter 11. The one that is at the forefront is the one that vests projects that were in progress prior to 1989 and February 1990. February 1990 is when currency was implemented. 1989 is when the comprehensive plan amendment. That obviously doesn't apply to us. We didn't come in until 2002. So we are not relying upon that section. Doesn't even apply to us.
Ms. Kirk, when did you say, you might have mentioned it, was the DRI approved?
The DRI was originally approved in 2002. There were non-substantial amendments in 2005 and 2007. And then under the new state law for DRI, which changed 2019, in 2019, they came in under those regulations, mostly to finalize the vesting for phase 2. And I can talk about a little bit more about that.
And is your development in phase 1 or phase 2?
We are phase 1. Okay. We are the last remaining entitlements, 1 or so units maybe of phase 1.
Okay.
So if you go to the code, the vesting section of the code, section 110201, it sets out, pursuant to the comprehensive plan, which mandates that we have a vesting section, what the county looks like when you go through a vested rights process. You hear those through this process, actually. However, that section expressly says, notwithstanding the foregoing, development specifically approved in a DRI development order is vested in accordance with section 163-31678 Florida Statutes 1987 and is exempt from the provisions of these regulations to the extent accorded by the statutes and the development order. So 2 things about that. 163-31678 is the same as the one that I just read to you, 163-31675. They renumbered it, but the language has not changed over the years. The other thing to note is that each DRI is different. We talked about the phasings in this particular project. Phase 1 was fully mitigated and fully vested. Phase 2 partially mitigated, but left out certain things that had to be mitigated before you could use your phase 2. Those were transportation, water, affordable housing, and air quality. So before you could utilize your phase 2, you had to go back and do another notice of proposed change and identify and mitigate for those remaining areas that were outstanding. My point on this section is twofold. Number one, we couldn't go through the vested rights process because the county has told us we can't because we're a DRI and we're vested under state law. But the other one is it gets you back to the same place, which is state law has said as expressly as they can that we are preempted. This is not a novel concept. We didn't look at all 67 counties. We looked at about a dozen, and about half of those, and that's a chart that I referenced earlier, they expressly copy the language from section 39 of Senate Bill 360, and they expressly use the dates May 1st. You either applied by May 1st or you were approved by July 1st. And those were Miami-Dade, Orange, Polk, Pasco, Collier, and Hernando. The other jurisdictions did not include that language when they implemented their school concurrency regulations, but they all have the same language as Hillsborough County, which is you're vested pursuant to state law. That's the essence of a DRI. I want to talk a little bit why it makes sense that the state has vested us. It goes back to the essence of what a DRI is. It's a large project that mitigates under existing laws, rules, and regulations at the time that entitlement is granted. DRIs are actually all required to address impacts on schools and education. In this project, we did. for phase one and phase two, and that's in part of the backup that we provided to you, part of the ADA, which was adopted as part of the 2002 resolution approving the DRI. And the mitigation that was requested and agreed to by the developer was to reserve an elementary school site. This project actually reserved an elementary school site, 15 acres, and a 50-acre high school site, which they subsequently sold to the school board. And now there is an existing elementary and high school within the DRI. This wasn't concurrency. It wasn't concurrency mitigation, but that's because concurrency was not in place. Had concurrency been in place at the time, as part of the DO, they would have mitigated and shown and had their capacity vested at that time, which has been done in other DRIs.
So just to slow up and confirm where we are, the DRI, the developer set aside land for schools, and that was sold to the school board. Schools were built.
Yes.
So it's mitigated. And yet now there's no capacity.
And yet now there is no capacity. Yes. The state, the DRI is a creature of state law. And as you know, charter counties have broad home rule authority. However, the state has retained the ability to preempt them when they choose. And that's how this worked. Perhaps they could have asked for more at the beginning, but that's not the situation we're in. We are in an improved DRI. And just by way of background, the 2019 amendment to the DRI wasn't reviewed under the same statutory framework that we're used to with a substantial deviation. However, it actually reduced the number of residential units from what was approved in 2002. And if you were to do the school mitigation today versus what was done in 2002 by the school board, you're generating less students. So we're vested under state law. I did include in your backup, and I sent over to the county attorney's office a case. I'm not sure if they've had a chance to review it. It's black letter law. It's just the most recent Supreme Court case on preemption. And it doesn't say anything surprising. It just says that despite the home rule authority granted to charter counties, the state retains the ability to expressly preempt them. I'm going to reserve any remaining time for rebuttal.
Okay, Ms. Curt, thank you.
Thank you.
All right. County Attorney's Office, or county, I should say, rather. I believe Mr. Gormley.
Yes. Good evening, good afternoon, Madam Hearing Officer. Adam Gormley with Development Services Department. I'd like to just frame what I think your role here is today and what my role here is today. This is an appeal of a decision rendered by me under the Land Development Code on August 6th, and it's relating to the South Shore Point Townhome Project, PI 5630. What I'm going to address to you is my decision under the Land Development Code. I think what you would have heard is argument that may or may not be relevant in perhaps this proceeding, but I believe you've heard some argument on things that are not relevant to this proceeding, and that namely is the effect of state law on this decision. Whether this project is or isn't vested pursuant to state law, or whether state law preempts the application of provisions of the LDC, I don't believe is the issue that is relevant to the appeal today, but rather whether my August 6th letter was in error. The county has a concurrency mitigation system that includes school concurrency mitigation. It's based in the comprehensive plan and codified in the Land Development Code. The purpose of these regulations, as stated in the Land Development Code, is to manage the timing of residential subdivision approvals and other approvals to ensure that adequate school capacity is available consistent with the adopted level of service standards for school concurrency. My letter cited to section 4.0204 of the Land Development Code that requires mandatory determination of capacity for preliminary plat. It noted that for this project, PI 5630, this was done. My letter cited to section 4.02.8 of the Land Development Code that provides that the school board, school district, shall conduct a concurrency review that includes findings and recommendations whether there is adequate school capacity to accommodate the proposed development impacts for each type of school. Based on the submitted plat for 5630, the application was sent to the school district for review and comment. And on January 25th, 2021, the school district provided a comment that at this time, there is no high school capacity available for the proposed units, and there is no cited and approved high school capacity project in the 5-year facilities work plan to enter into a proportionate share mitigation agreement. Therefore, the application is unable to meet the level of service. In my letter, I rendered the decision that based on these requirements of the Land Development Code and the statement from the school district determining that the level of service cannot be met, it was my decision that the application, the preliminary plat, could not be approved under the provisions of the Land Development Code at this time. And Madam Hearing Officer, that really is, I believe, the crux of the issue that's before you today. This is an appeal of my decision under the Land Development Code. I fully recognize that there are other arguments being made, some of which are memorialized in the record, that have to do with the effect of state law on this decision. However, I believe that the decision I rendered under the Land Development Code was the correct decision given the facts that are relevant for this matter. And with that, I'm available for any questions you might have.
Well, I guess it could use a little help understanding. I'm not sure I follow. I understand your definition of the issue, or your framing of the issue, Mr. Gormley, is different from that of the appellants, but I'm not sure I understand fully why. So, I hate to say, gosh, say all of that over again, but, are you saying that the applicant's argument doesn't quite get to the reasons you denied the preliminary plat?
Yes, the applicant's arguments seem to get to a decision that relies on application of state law rather than one that is a decision of the administrator under the Land Development Code, which is what is subject to appeal to the land use hearing officer. So yes, I believe that their argument gets to items that are outside of the administration of the Land Development Code as presented, and therefore outside of what can be what would be appropriate for the review of my decision under this process.
So I understand the county's, so you reviewed the application, your denial cited Land Development Code, section 40204 and 40208. So you're relying on Land Development Code,
Yes.
adequate public facilities provisions. And do these provisions then apply even for a plat coming in that is in a DRI?
There, for this particular plat, there was no valid vested rights order that was associated with it as contemplated by the Land Development Code, nor do I believe that the development order provided for non application of uh, subsequently adopted regulations or something of that nature. So I believe for looking at the administration of the land development code as written, the code provisions that I cited are the applicable ones.
All right. How does the DRI, the existence of the DRI, come into play at all then in your considering whether to approve or not approve a plat?
Well, there is exemption language in the in part 4 that, and I say that this is, I'm answering the question, but I don't believe this is relevant to the appeal because it doesn't fit this fact set. In 40302B of the code, there is a recognition of a development of regional impact with a development order issued before February 1, 1990, that has a detailed analysis of public facilities impacts or an approved phase thereof. It is an explicit exemption from the concurrency regulations in the code.
How does state law affect this whole question of whether school concurrency applies to this DRI and this preliminary plat approval? How does state law apply that, and specifically Chapter 380?
Madam Herzog, if that question is for me, I would say if it does apply, it applies outside the corners of the land development code. So I believe that is still an open question that needs to be decided. But again, I believe that is a question of a decision under state law as opposed to a decision under the land development code.
Well, if there is a preemption, is there a preemption?
Madam Hearing
That's a question for me, Madam Hearing Officer. I don't believe I'm qualified to answer that for this proceeding.
Madam Hearing Officer, this is Cameron Clark. Just a quick, the context of this appeal is a little unusual for what we're used to getting. So I would say that if the appellant is taking a position that there is no conflict between state law and the land development code, but that development services erred in their application of the LDC on the application, then this is obviously what this venue is for. So because the authority of the hearing officer is to determine if there was an error in the administrator's decision, and then if that determination is made, the hearing officer can take any decision that the administrator could have made under the land development code. If instead the appellant's position is that the administrator could not apply the land development code as it was applied because the land development code is preempted by state law, then this isn't the venue to address that issue because the hearing officer can't, it's outside the authority of the hearing officer to determine that a provision of the land development code is unenforceable or preempted. I mean, historically, going back in all my years of sitting with the hearing officers, most of our hearing officers aren't even lawyers. So I think my concern in listening to this is that and I would want some clarification from the appellant, but if the position is, again, that the LDC can't be enforced because it's preempted by state law, this isn't the venue, I think, for that.
Thank you, Mr. Clark. I understand that. I appreciate that. Okay, Mr. Gormley?
Yes, ma'am.
I think that helps me understand your arguments as well. Did you have anything else you wanted to add?
Nothing else, Madam Hearing Officer.
Okay. All right, thank you very much. Then applicant, you have rebuttal? 5 minutes for rebuttal.
Thank you, Madam Hearing Officer. I do want to note that we originally sent our request to the county attorney's office and to date have not received a response. The only response that we have received is the letter from Mr. Gormley, which we were told we were able to appeal. However, I do respectfully disagree that the code is in conflict. The code says in section 110201, development specifically approved in a DRI development order is vested in accordance with section 163.31678, which was 5, or is now 5, Florida statute, and is exempt from the provisions of these regulations to the extent accorded by the statutes and the development order. It seems unfair to my client to have the code direct you to state law and then to say no one can consider state law. That is what the code, in fact, directs you to do to determine whether or not we are vested. We aren't able to go through the vested rights determination process. And if we can't get relief through this process, my client's effectively being denied due process because nobody is willing to effectuate the clear language of the code, which directs you to state statute. Again, many jurisdictions did put those dates in their code and expressly exempted them from state statute, but the fact that you did not does not mean that you can apply school concurrency in the face of state law. And we are respectfully requesting to get a response from the county acknowledging that the code directs you to state statute in this instance to determine whether school concurrency applies, and that the state has, about as clearly as I've ever seen, agree with it or disagree with it, expressly exempted us from the application of school concurrency to this particular DRI in this particular set of facts.
Okay, thank you, Ms. Kurt. Do you agree the issue is not that there's a conflict between state law, Chapter 380, and the Land Development Code, but the issue is just that the zoning administrator erred in denying the preliminary plat based on the Land Development Code?
That is correct.
You agree that's the issue?
I do agree that that is the issue. We believe that the code directs you to the state statute, but we don't, and therefore there isn't a conflict.
Okay, thank you.
Thank you.
All right, that closes the hearing then on Appeal 21-1295. And that concludes our Land Use Hearing Officer meeting for today.